desired progress. So once again, I would like to welcome us to this class, and then the topic we'll be considering is English courts and non-English courts. English courts and non-English courts. And of course, this will cover customary and non-customary courts. And we're going to start by looking at the English courts by way of definition, and then we take the discussion further from that point. So the first question we need to ask is, what are English courts? What are English courts? English courts are courts established in England and Wales, which became the major part of the Nigerian legal system as a result of colonization. Okay, we keep on talking about our colonial heritage and how the same has affected our operation today, and not just basically on our legal system, but even practically on every area of our lives. So English courts are those courts that were established in England and Wales, and by virtue of our colonial heritage, they are part of our legal system. And this means that the Nigerian courts apply many of the principles and procedure as the English courts. And like we rightly said before now, that there are quite a lot of laws we have in the country as of today that are, were gotten or were like what were kind of transferred to us through that colonial relationship. And some of our activities today, our laws, our procedures in court, and so on and so forth, also still manifest the procedure and practices that we got from our colonial masters. So English court system is a complex network of judicial bodies that are involved over countries to uphold the rule of law in England and Wales. And this court handles a wide range of legal matters, of talking even from criminal cases, civil disputes, and also play very important roles in the country's legal framework. And one of the things that we need to mention about the English court is that the English courts are highly hierarchical, meaning that they have structure, and this structure flow from the topmost to the least of those courts. And that is one of the major characteristics that we need to note about the English court system. And with that, we also still submit that those courts that are not referred to as customary courts are non-customary courts. And these non-customary courts are referred to formal legal systems that are established and recognized by law, typically operating within a statutory framework rather than relying on customary law or traditional practices. So, when we speak of English court, which we have broadly classified as non-customary court, the same definition and meaning will also apply to courts that are not customary courts. So therefore, English courts and those other courts that are, established or that are based on, statutory frameworks that don't rely on customary laws or customs or rule of customs and regulations are, courts that we refer to as non-customary courts. And again, we'll submit that English court system will fall under that. Okay? This non-customary court, just like we have discussed on the English court system, they are established based on statutory provisions. They are and constitutional principles govern them, and even the various cases that they attend to. And again, like the English court, generally speaking, non-customary courts also handle a wide range
How long will it take? I need to leave now.
Criminal cases, administrative
Not
matters,
the other one,
and also apply what we know as precedent, which flows from higher court down to the lower court. So therefore, that's simply just explain what non-customary court is all about. And of course, we speak of English court as an example of this. So the next thing we need to look at on this is the jurisdiction and authority of English courts. And we will discuss this under subtopics to include one, territorial jurisdiction. We'll also discuss it under subject matter jurisdiction. We'll discuss it under hierarchical structure, and we'll also discuss it under precedent. So, what are the jurisdiction and authority of English courts? Starting with the territorial jurisdiction, we say that English courts have jurisdiction over matters that occur within the geographical boundaries of England and Wales. And this will include civil and criminal cases that originate from these various this region or jurisdiction. And what that suggests simply is that the English courts and even most other court systems operate what we call territorial jurisdiction. And that's why, for example, in Lagos State, we have a Lagos State High Court. We have the High Court of Oyo State, and so on and so forth. The Lagos State High Court can attend to civil and criminal cases that originate from within Lagos State, and it may be limited to meet its operation to Lagos State, because if the laws are laws of Lagos, they are only operational within the Lagos territory. So the jurisdiction and authority, when we talk about of English court, when we talk about under territorial jurisdiction, we are saying that they have jurisdictional boundaries over cases that originate in England and Wales, which is the territory for which this court is established. And they try all sorts of criminal or civil cases. And these civil cases that the contract can be issues pertaining to land disputes, can be which can also be matters pertaining to economics and so on and so forth. But what is of most importance to us at this level of discussion is that whatever type of cases they fall into, all of them are uh, within the English legal system, and then they operate within the English legal system. And I did explain that just as we have laws of Lagos State that bans Lagosians and those that transact within it, so also are other laws of other states that also operate within their territory. Then moving on, we also talked about subject matter jurisdiction. And I'm very sure that the term jurisdiction is not new to any of us. And we have discussed extensively on this in time past. So when we're talking about the jurisdiction and authority of English court, under when we're talking about this under the subject matter jurisdiction, we say that the courts have the authority to preside over a wide range of legal disputes, including contract, tort law, property law, and family law. While the first one we dealt with was specifically on jurisdiction, that is, on territorial boundaries. The second one we are considering, which is the subject matter, and pertains to contracts, law of tort, property law, family law, and so on and so forth. Those classes of law that I mentioned are what we can also refer to as subject matter cases. Okay, there are courts, for example, that deals with only criminal. They call them criminal division. There are courts that they deal only on properties, maybe the land cases, and so on and so forth. So the English court also deals, it can also be looked at when we consider the jurisdiction under the subject matter jurisdiction. And like we've said, can handle cases that pertains to contract, that pertains to property, that pertains to family, and so on and so forth. Then what about the hierarchical structure? The English judicial system is organized in a hierarchical manner, with the Supreme Court at the apex. And of course, that is the same with our system here in Nigeria, where we have the Supreme Court as the number one court in the land, followed by the Court of Appeal and other courts that have been established by law as courts of record in Nigeria. So, but what we are saying in essence is that the court, the English court, is organized in a hierarchical manner. There is order, there is simplicity, in the structure. And then on precedent, because we talk about the jurisdiction on subject matter, territorial boundary, hierarchical structure. Now we talk about precedent. We know that the principle of stare decisis, where lower courts are bound by decisions of higher court, is a cornerstone of the English legal system. Of course, we practice that here in Nigeria, and that's because of our colonial heritage with the courts in question. So there is the practice of the doctrine of stare decisis, which is also known as judicial precedent. Now, the English court system in Nigeria has several characteristics. Mind you, at the beginning, we did say that the English court, one way or the other, is manifested in our legal system because we copy the system into our law. And that's why we are looking at the subtopic that says the English court system in Nigeria. What are the characteristics? What are the characteristics? And mind you, the characteristics we are going to look at here, they also represent the characteristics also in England. The only variation will be as to the peculiar situation of each country, as we will see in this subtopic, that is the characteristics of English court system in Nigeria. So number one is that the English court system is adversarial. Adversarial. I'll spell that. Adversarial is ADVERSARIAL. So, like in England, Nigerian courts follow an adversarial system. And what does the adversarial system mean? It means that parties will present their cases to the court. The court is a neutral party, and the other people who have cases against each other will present their cases. And this is very important because the court will not assist anyone to prove his case, which is to say that whatever argument you are able to make before the court is what determines the kind of judgment that you have. So, number one is adversarial system. Number two of the English court system in Nigeria, that is the characteristics, is hierarchy of court. Okay, just like we discussed about the English court, we also have the same system in Nigeria. In Nigeria, the Supreme Court is at the top, followed by the Court of Appeal and other various levels of high courts, and customary courts that exist in Nigeria. Number three of the characteristics is common law. Nigerian courts apply English common law principles and statutes which have been adopted and modified to suit Nigeria legal context over time. So, meaning that a English court system in Nigeria still embraces the common law, that is the principles of common law and the available English statutes. But of course, it's believed that they have been amended or transformed into what is known and acceptable as our own laws. So we have mentioned adversarial system as one of the characteristics of the English court system, the hierarchy of court, common law, and the fourth one is judicial precedent. Of course, again, judicial precedent talks about the fact that decision made in higher court serve as a binding or persuasive authority for a lower court. And then the fifth one is legal profession. The legal profession in Nigeria is modeled after the English system, with lawyers trained similarly and practicing in court following England legal procedures. So that is also one of the major characteristics of English law system in England and also applicable in Nigeria by virtue of our colonization. Okay, so note these five characteristics, and then the sixth one is the use of English language. I hope you can hear me, class. The use of English language. English is the language of the court in Nigeria, and this also reflects the thank you for the confirmation. This also reflect the colonial legacy and facilitating legal precedent in a linguistically diverse country, because Nigeria has a lot of languages, but English language has been adopted as the language of the court. Number seven characteristics is independence of the judiciary. Like in England, the Nigerian judiciary is constitutionally independent, with judges appointed based on merit and expected to adjudicate cases impartially. Whether that is what is obtainable presently or not, it doesn't stop the fact that as it applies in England, where the judiciary is independent, also in Nigeria, one of the major characteristics of the Nigerian judiciary is the fact, or court system, is the independence of the judiciary. And the last one is influence of statute law. Influence of statute law is another characteristics of English court system in Nigeria. Alongside common law, Nigerian court also applies statutes enacted by the Nigerian legislature, which may include laws inherited from England legal tradition or domestically crafted legislation. So, but what we are saying is that Nigerian courts apply statutes. So, we have mentioned about 8 characteristics of the English court system in Nigeria. Number one is the hierarchy of court. Number two is common law. Number three is adversarial system. Okay, we mentioned that one as number one earlier. Number two is hierarchy of court. Number three, common law. Number four, judicial precedent. Number five, we have legal profession. Number six, use of English language. Number seven, independence of judiciary. Number eight is the influence of statute law. So let's move on to look at what is a non-English court. We've taken time to look at non-English court. So I mean non-customary court, which also means English or other legal system that are not purely customary. So what is a non-English court? Non-English court primarily refer to customary or traditional courts that operate along the formal legal system in Nigeria. So we know the formal legal system in Nigeria is the English system, which we are adopted by virtue of our colonial heritage. So therefore, non-English courts refers to customary or traditional courts that operate within Nigeria. They are courts that are established the indigenous legal order. That is, they established the customary law even before we were colonized. Even before we were ever colonized. So, what are these courts? They are those courts that refer to any judicial system that operates outside of the legal framework established by the English court. So any court that is established outside the legal framework of the English court in Nigeria is referred to as the non-English court. And these courts administer justice based on indigenous customs, traditions, and norms rather than English common law. Okay? They administer customs, that is our customary rules, our customary law, rather than the principles of common law, rather than the principle of equity, rather than those principles that are identified with the English common law. And also, this non-English court handles various civil and criminal matters within local communities, particularly in rural areas where formal courts may not be easily accessible. Of course, there are several parts of Nigeria where the formal courts are far away from. And of course, it doesn't, in all these localities, do not have need of a legal or a court system. So the law is called exists at all these levels to take care of needs of the people within that geographical area. And non-English court follow different rules and procedures and traditions, okay, such as Islamic law or customary law. Those are the laws that deploy in on matters that need to be brought before them. And the good thing about this is that customary courts are recognized under Nigerian law and often deal with issues such as land disputes, family matters, issues related to inheritance, minor criminal offenses. Okay? And then all of these are the subject matter that the customary court deals with in Nigeria. So, therefore, non-English courts can be found in countries and territories that were part of the British Empire and have now gained, their own independence. And in Nigeria, we practice non-English court, which can also be referred to as customary court or law, because it is accepted and binding among us. Okay, so that is the brief of customary law here. Yes, Odunayo, you have a question. Please go ahead.
Yeah, excuse me, sir. Your voice sounds a bit muffled. We can barely hear you.
Even now?
Yeah, okay. Yeah.
Now?
Yes, I can hear you now, but it was a bit muffled before, and it sounds like you were far away.
Okay. All right. Sorry about that. So we move on from there to look at the characteristics of non-English courts in Nigeria. That is characteristics of non-English courts in Nigeria. indirectly we are talking about characteristics of customary law. Number one is indigenous customary law administer justice based on indigenous custom, traditions, and norms that are specific to a particular ethnic group and also operate within their jurisdiction. So they administer justice based on indigenous custom and tradition. And of course, this is easily understood in that the Badagry people of Lagos State may have their own customs that are different from those of the other parts, other known tribe within Lagos State. If there is any court that's to administer anything in there, that court, we apply the customary law and the rules of tradition over there. So number two is informality. Informality. Proceedings in customary court are often less formal compared to English courts, with emphasis on reconciliation, mediation, and community involvement. And for those who were with us when we discuss when we discuss the various traditional system of dispute resolution, we will discover that we've established times without number that the customary court often seek for harmonious living, often seek for unity among the society, so that if there is need to bend the rules to make parties to be happy, the customary system embraces that. Unlike the normal English court where the people can be in court for years, customary court will ensure that that does not happen by embracing reconciliation, mediation, and other system of dispute resolution that may be acceptable by the parties within that jurisdiction. Also, another characteristics is oral testimony. Oral testimony. Oral testimony. Customary law is predominantly oral, and I believe you will recall that that is one of the major characteristics of customary law as a system of law. Okay, and they give their evidence, by presenting same in court orally, where parties or witnesses give their account, in the open court by saying it rather than writing them down or in a particular document as it is common with the English court system. So the characteristics of non-English court include indigenous customary law, informality, oral tradition, and the fourth one we want to look at is local jurisdiction. So customary courts typically have jurisdiction over specific local areas or community. And what advantage that this brings is that it makes it accessible to people within that geographical location. Okay, that's one of the advantages that have been attached to this particular system of law. That apart from that, another characteristics is preservation of culture. Okay, this court, like I rightly established, plays crucial role in preserving and promoting indigenous culture, tradition, and even social norms within their
I don't know what to say.
all the effort of the the court is to see how parties can amicably settle their dispute, how the society can thrive in one voice, and so on and so forth. Okay, so that is one of the major characteristics of non-English court. Another one is elders or chiefs as judges. This system embraces elders or chiefs as judges, unlike the English court where court judges are established, are appointed formally, and the level of education is also required of them. But in this system, elders and chiefs are used or deployed as judges. Then number 7 is flexibility and adaptability. Customary law is flexible and can adapt to changing societal needs, and it may also face challenges in reconciling traditional practices with modern legal concepts. But what we are saying is, like, unlike other systems of law that are very rigid, that are written, customary law being one of the laws that are largely unwritten, possesses flexibility, to easily adapt to the needs or the changing needs of the society. Another characteristics is appeal to higher court. Okay, appeal to higher court. While customary courts may make decisions independently, please note that their judgment can be appealed to higher court within a formal legal system. Okay, when a party who subjected himself to that particular court believes that his right has been violated, not to a higher court for re-evaluation of that judgment in order to ensure that their rights are protected. And again, that speaks to the fact that customary law system also embraces appeal to higher court. Okay, so those are the characteristics that we are going to identify in the course of this discussion. Okay, so now before we close, we are going to quickly look at the key differences between English court and non-English court. Or maybe I should start by asking the class to identify the differences between the English court and the non-English court, that is the customary court. The floor is open for people who may want to identify the differences between the both systems. Anyone? Yes. Olamide, please go ahead.
Okay. Good afternoon, sir. So from the characteristics that you've mentioned, one difference that I can highlight is the fact that English courts have a well-defined judicial structure. That means they have judicial precedent. Yes, the decision of the higher court are binding on the lower court, and they have a legal structure. That's what I was looking for. A legal structure, a well-defined legal structure, and they are mostly codified. While customary courts are mostly dependent on words of mouth, oral words, and they are largely unwritten, they are informal. Yeah.
All right, thank you very much. Thank you. Yes, any other contribution? Okay, there's none. Many thanks to Olamide for that contribution. So the differences are: number one, judicial structure. That's number one, judicial structure. Number two is procedural rules. Procedural rules. Number three is legal reasoning. Legal reasoning. Number four is judicial independence. Number four is judicial independence. While number five is geographical structure. So let's take them one after the other and explain. And of course, that we also, some of these explanations we agree with what Olamide already told us when she was answering the question. Judicial structure. English courts have a well-defined hierarchical structure, not like we said, with the Supreme Court at the top, whereas non-English court may have a more varied and complex judicial system. Okay, but that of English court is known, the hierarchy is known that this court is number one in the land, and its judgment whatsoever are binding and persuasive effect to the court below. Then when we talk about procedural rules as one of the major differences, we did say that English follow the common law system and practices the doctrine of stare decisis, okay, and also employ what we call the adversarial proceedings. So English courts adhere strictly to civil law traditions with more inquisitorial processes, and it has flexible, unlike the non-English courts. The non-English court adhere to civil law traditions, okay, with more inquisitorial process. They don't just follow the procedure, they really want to get to the roots of the matter. And of course, we did say that it's a flexible type of court. Then number four is judicial independence. English courts are widely recognized for their independence from political influence, while it is not recognized for independence through political influence because it is based on custom of the people. Okay, English courts highly recognized, by the system where they are practiced. And the last one is the geographical structure. And like we said earlier, English courts operate the what we call the territory or territorial structure, in that its laws and operations apply to all countries, in England and Wales. The same thing applies to the customary law. Customary law or court rules and apply to matters that falls within its geographical structure. And so those are the major differences that we have between the English and non-English court. So we like to pause here for today. It's supposed to be just an hour class, and I think basically we have achieved the purpose of the class, which is to discuss the non-customary, the English court and non-English court. And I believe we have done justice to that already. Do we have any question from any member of the family or the class before we call it a day? I've said family, we're also a family, and then again, we are course mates and all of that, those of you who are students. So, do we have any question? Any question? So it is believed that the topic is well understood. So by the time we meet again, by the grace of God, in continuation of the scheme of work for this subject, we will start with courts of original jurisdiction. Courts of original jurisdiction. Okay? All right, so we call it a day here. Thank you very much for listening and enjoy the rest of your day. Bye-bye.